Does USCIS sometimes make dumb mistakes? Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States out of our offices in St. Louis, Missouri. I'm coming to you live with a hot new approval, a great result on a case that we have been fighting for quite some time. We have a client who applied for citizenship, and the local field office of USCIS conducted his interview, and they confronted him with some of his past arrests. Now, this fellow applied for citizenship in 2020, and for those of you who don't know, USCIS uses a 5-year look back, so you need to show 5 years of good moral character when you apply for citizenship, and they actually move backwards from the date on which you filed, and they say, have you exhibited good moral character for the last 5 years? USCIS does have the ability to look beyond the 5 years. That's on a discretionary basis, and they sometimes use old convictions or even arrests to try to deny someone their naturalization, and that is exactly what happened here when we first filed the N-400. So our client was a young man who came from Bosnia a long time ago. His family had survived during the genocide in Bosnia. He had moved to the United States as a teenager. And when he was younger, back in the early 2000s, he was a little bit of a hellraiser and he got in a little bit of trouble. Nothing too major. A couple of arrests that ultimately ended up not going anywhere. They did not end up in a conviction, and he did not do any kind of jail time. So these convictions were on his record. Fast forward to 2020, he's applying for citizenship. And the officer who was conducting his interview, I believe, made two big mistakes. The first one was that she treated an arrest that didn't go anywhere as a conviction and treated it as if the allegations contained in the police report were 100% true. The big issue in this case was the fact that back in 2008, our client had been out drinking and he was crossing the street, walking across the street, and two people pulled up beside him and they almost hit him, and he got mad and hit the car. Well, it turned out that the car was an unmarked police car, and the police officers sort of threw the book at him. They hit him with about 5 charges, and one of the charges involved an allegation that he had ecstasy on him. Well, he didn't have ecstasy on him. He had heartburn medicine on him, and the charges related to the drugs were dropped. So he did get a peace disturbance conviction, just a misdemeanor, no big deal. And again, this was back in 2008. He applied in 2020, and the officer went way beyond 2015, which would be the 5-year look back, and used that 2008 incident as a basis for denying him his citizenship. They also went ahead and said that he had lied to USCIS at that naturalization interview by simply denying the fact that the pill was ecstasy when in fact it was heartburn medicine. There was no indication in the records, no indication in the police reports that the pill at issue had been tested, and the prosecutor had dropped the case. So we believed that that demonstrated that our client was telling the truth. If he hadn't been telling the truth, and if it was in fact ecstasy, they would have charged him with that, and they didn't. So that was our position at the naturalization interview. The interview did not go so well, and the officer ultimately denied the case. We were upset, our client was upset, so he went ahead and hired us to file an N-336, which is an administrative appeal of a denied N-400. So this means that you get another hearing, you get another chance, you get another bite at the apple, and my client and I had that interview yesterday, and we met with an officer who has been there for a very long time. We went over the case. We went over the traffic issues. We went over that 2008 conviction. My client made it clear that he never lied. We also made it clear that the charges had been dropped and that there had never been any determination that he did in fact have drugs on him. He denied ever having any drug use, and there was no evidence to the contrary. Now, one thing that you should keep in mind when you're taking an appeal, especially of a denied N-400, is you might want to think about how to give the officer an out, because after all, we're asking the officer to conclude that their friend or colleague down the hall made a mistake. And so it's important to spend some time thinking, how can I help my client and get his case approved without throwing that original officer under the bus? Now here, I think this officer had made 2 big mistakes, and I think they were sort of obvious, which is why we believe that filing the N-336 and getting naturalization for our client was a real possibility. It seems that the officer we met with yesterday agreed with us, but we framed it as really important for her to pay attention to the fact that those charges had been dropped, and we had proof that the charges had been dropped. And while we didn't have a lab report because the police department had never sent it for a lab report, we put together a pretty basic argument, which was He'd been arrested. They claimed it was ecstasy. That claim went nowhere. He was never prosecuted for it. It was dropped. And there was no evidence that the substance had ever been tested. So therefore, the officer simply made a mistake when she was concluding that what was in the police report was accurate. Now, this is not the first time this has happened to us. This is not the first time that this has happened to our client. So we know how to frame it, and we know how to allow the new officer to reverse it without throwing the officer under the bus. And I think that's really, really important. We're certainly happy for our client. He was ecstatic. He was super nervous yesterday. He was calling the office. I was there 15 minutes early, but he was calling thinking that I wasn't going to be there. He really wanted his citizenship, and as of today, he's really, really happy. He's been placed in line for an oath ceremony. So the lesson here is that oftentimes USCIS makes mistakes, and they're not God. They're not infallible. They definitely make mistakes. They're an administrative agency run by human beings, and you have to be careful about what you appeal. And you probably don't want to appeal every decision, but if they make a very clear error like they did here, one that you think is simple and easily understood by someone reviewing the case, then that's probably your best bet at filing an appeal. If you have a decision that you're not happy with, or if you're thinking about filing an appeal or filing a whole new application with USCIS and you would like our help, feel free to give us a call at 314-961-8200. You can email us at info@hackinglawpractice.com. Be sure to join us in our Facebook group. It's called Immigrant Home. We'd love to have you in there. There's almost 8,000 people in there now, immigrants talking about their cases, their processing times, and their headaches. And then we have our YouTube channel that you should subscribe to so that whenever we make a video like this one, you get updated. Lastly, make sure that you join us on our Immigration Answers live show. You can just Google Immigration Answers live show, or you can join the Facebook group or subscribe to the YouTube channel, and then you'll get alerted whenever we're about to go live, usually Monday, Tuesday, Wednesday, Thursday. For about an hour, I'm answering as many immigration law related questions as possible. Thanks a lot, and have a great day.